we'll start with you.
Thank you, Mr. Chairman. Ms. Sagam, I want to follow up, and we got in the discussion a little about the impact on climate change, and I assume the BLM's proposed rule is intended to regulate the capture of methane, which is a pollutant in the atmosphere, in an attempt to address climate change. How effective is the proposed rule in impacting global emissions in a meaningful way?
By BLM's number, it would reduce emissions by 0.00092%. So that is a very de minimis amount for a large cost. And it's putting at risk the much larger benefit we provide on the electricity generation end. You know, electricity generates 10 times the emissions that the producing sector does, the oil and natural gas producing sector. And we deliver those benefits by providing those climate benefits in a sector that has 10 times the emissions. If we constrain natural gas production, we put that much greater climate change benefit at risk.
We saw a similar kind of analysis when we looked at the impact of the EPA power plan. They ran that through the EPA's own algorithm, MAGIC it's called. The impact on global temperature between now and 2100 was 0.02 degrees centigrade. Back to using the terms de minimis. Ms. Leiter, are these numbers coming out of the BLM in terms of this 0.0092% reduction in emissions?
So I'm not sure exactly what number Ms. Sagama is pointing at, but the Supreme Court has been very clear that agencies have the regulatory authority to take the steps that are needed toward what is a more comprehensive solution. The BLM is not under any illusion that it is solving climate change with this rule.
I understand, but it's all as we have to weigh trade-offs in terms of a cost-benefit analysis. We've seen, and there's some disagreement in terms of what the cost will be here.
Certainly.
The benefit, arguably, is perhaps de minimis, and we've seen this with the EPA power plan. Literally 0.02 degree impact centigrade on climate temperature between now and 2100 for what will be a devastating effect on our economy in Montana. And this is just looking at these trade-offs, which is always what we have to do here is balancing pros and cons. Let me go back to Ms. Sagama here for a moment. You mentioned in your written testimony that the industry has an interest in capturing methane waste. I'm wondering, what is the industry doing to improve efficiencies then to manage methane waste, and what are some of the challenges to bringing that product to market?
Well, it's not always in the control of the operator to capture that methane because in the case of BLM, we've got a backlog of rights-of-way. So we have wells where we can't get the approval to put in the gas gathering lines and the pipeline to collect that natural gas. So we have no choice but to flare it. Even when lines are put in place, there are maintenance issues, there are downtimes on the pipe, or there could be situations where new wells come online and then the pipeline reaches maximum. So there are times that there will be downtimes even if you're connected to that pipeline. And the way BLM has interpreted this in the past is, you know, if it's reasonable, if they're determining what's avoidable and what's unavoidable. And certainly maintenance issues, operational issues, pipeline capacity issues, gas plant capacity issues, where there's nowhere to put your natural gas, that is certainly a situation which should be considered unavoidably lost. And
my understanding is that when they have the excess methane, in terms of it requires some permitting for gathering lines as well. Right. And that's that's part of the solution here, and is it also a barrier as well?
Well, BLM could virtually overnight decrease flaring rates by simply approving the rights-of-way applications before it now for gas gathering lines and pipelines so that we could connect to that pipeline, get that gas to market.
And how significant would that be in terms of reducing the amount of flaring?
I don't have a number to quantify that, but I think Senator Barrasso had a number of close to 900 rights-of-way that are waiting, that are awaiting approval. And so some of those are for over 2 years. So in the meantime, that operator has had to flare for 2 years.
So if that's a possible barrier here to trying to do the right thing to reduce the methane emissions, maybe turning back to Ms. Leitner, does the BLM have a policy for prioritizing permitting of gathering line systems to capture gas, which would otherwise be vented or flared, and then we could have it transported to consumers?
So I have a couple pieces of the answer to that question. The first is no, we don't prioritize rights of way based on some estimate of the flaring that would otherwise occur, but we are working hard to reduce backlogs. My understanding is that in some states where there are significant numbers of rights of way pending, that can be due to market conditions. So for example, in Farmington, New Mexico, something like 60 of the pending applications are actually awaiting additional information from the applicant, and the applicants have actually asked us to hold the applications until market conditions improve. But the other point to make is that at least 20% of this problem is due to leaks and things like that that can be repaired where the presence or absence of a pipeline is unrelated. And another piece of the problem is that there needs to be more proactive planning by operators as they drill, more communication with midstream companies, et cetera. And one purpose of this rule is to require that operators submit a capture plan at the time of drilling, so that we can ensure that they've thought ahead about how to make sure that the capture infrastructure is in place in a timely way.
Okay, thank you. I'm out of time. Thank you.